Okay, welcome everyone. My name is Francesca Mangano, and I'm a Master's in Social Work intern on the Crossroads for Hope team. I'm joined here by Kyle Jackham, one of our licensed social workers, and of course, our presenter today, Christine Soletti, who is a trust and estate lawyer and principal at Porzio, Bromberg and Newman Law. I'm so excited to welcome you all to the first session of our three-part Planning for Peace of Mind educational series. The purpose of this program as a whole is to bring awareness to the available resources for advanced planning, equip individuals with tools to communicate their end-of-life wishes, and empower all people to take control of their own future, health, and well-being. Now, we each have our own unique experiences, wishes, and beliefs around end of life. So this is by no means a one-size-fits-all process, but nonetheless, everyone deserves the right to self-determination, autonomy, and dignity. And as an organization, we believe that just by destigmatizing these difficult conversations and providing information about both the legal and medical processes, we can bring you just one step closer to fulfilling those rights. Please note that at the end of the three-part series, we will be sending out recordings of the presentations to all individuals registered, along with a Planning for Peace of Mind resource guide. And this guide will offer helpful information and handouts on the topics discussed throughout the next few weeks. To those of you who may not be familiar with our organization, Crossroads for Hope is an independent 501c3, a nonprofit organization located in Bedminster, New Jersey. And our network of support embraces all people touched by cancer, the diagnosed and their loved ones, providing access to resources and evidence-based programs of support, education, well-being, and hope, all offered free of charge. Our vision is to be a safe space to turn to first for restoring one's whole being and improve the life of people with cancer and their families beyond the diagnosis. This first session of our series is in partnership with Porzio, Bromberg and Newman Law in Morristown, New Jersey. And the presentation today will focus on learning how to manage and direct our assets through powers of attorney, living trusts, wills, and planned giving. Throughout the presentation and after, you can feel free to drop any questions or comments you have in the Q&A box or the chat box, and we'll be sure to get to them at the end of the presentation. Thank you so much for joining today. And Christine, I'll hand it off to you. Share my screen. Hold on.
Great. Thank you, Francesca. Thank you all for joining us today. As Francesca said, I am a trust and estates attorney. I've been practicing for over 20 years in this field, so I regularly advise clients on estate planning and related items, estate administration and whatnot. This is not the first time we've done the Planning for Peace of Mind program. It has been very successful in the past, and I'm glad that you all joined today. I hope that it is as successful in this format. This is the first time that I am doing this Planning for Peace of Mind Zoom format. So generally, like I said, it's a discussion, but hopefully I'll get all of the information out to you. It is a very broad topic that we're talking about today. I'm going to try and be very general and give you a general overview, but there will be a lot of information for you to process and listen to. The planning that I do, estate planning, is not a one size fits all. It's different for everybody. And everything I say today, I'm going to be speaking in general terms. As Francesca said, if you have questions, you can raise your hand, or you can save your questions for the end, and we will have a Q&A. But I hope that you all get some good information from this discussion. And the other thing I'm going to say is, please forgive me I am not that tech savvy, so I'm going to have to keep asking Francesca to move the slides along when it's ready. So you'll hear me keep saying, go to the next slide. So Francesca, if you could go on to the first slide. So why do we plan? This program is called Planning for Peace of Mind, and you'll hear that word a lot. We plan for so many things in our lives, right? We plan for weddings, and we plan for college, and we plan for other sorts of education and new jobs and vacations and parties. We plan because we want things to go the way we want them to go. We want to think about how we want something to turn out. And so we have to make a plan. We also, in this area for estate planning, we want to plan because when you are incapacitated or you're gone, your loved ones have to pick up the pieces and finalize everything and take care of things for you. So you want to prepare them. You want to prepare yourselves and your information so that it's easy for them to find. And I have seen clients who don't plan. I've seen their loved ones come to me afterwards and say, I have no clue what to do. I have no clue what my parent, spouse, friend wanted. I don't know where their assets are, but I know, people are knocking at the door and needing money, or, there are things loose ends that need to be tied up. What do I do? And it's very confusing for them. And then I see other families who, their parents have, or their family members and loved ones have planned and set forth all of their instructions and their thoughts on how they want things to go. And it's so much easier for them. So controlling your assets during your life and after death is part of planning, tying up loose ends for your loved ones and making things easier for them. And then, of course, planning, you can plan to save taxes so that more of your assets can go to your loved ones and favorite charities. Oh, thank you. There are laws in every state that allow for planning and direct what happens, how you can plan and what are the legal documents required and the legal steps you need to go through in order to make a plan that people will follow and will be required to follow. And then there are laws regarding what happens if you don't plan. So regarding planning, state laws that allow planning, there is a state law that allows you to create a living will, an advance directive for healthcare. That will be talked about in another session, but that is a document that expresses your wishes for end of life care and who you want to make medical decisions for you in the event you are unable to make those decisions for yourself. Again, that'll be talked about in the next couple of sessions. There are state laws that allow planning, so you can create a durable general power of attorney. Believe it or not, some states don't allow for a durable power of attorney. But a power of attorney is a document that expresses your intent to give somebody else or some other people the ability to transact your financial and legal affairs on your behalf in the event you can't do so. So a living will, an advance directive, and a power of attorney are in existence during your life, and they are effective only while you are living, but perhaps you're incapacitated or unable to or don't want to manage your own financial and legal affairs. The power of attorney is the document that allows you to name somebody else, and that gives your attorney in fact or agent the ability to legally transact those affairs on your behalf. And then there are laws regarding testamentary instruments, and testamentary instruments are instruments that pass your assets and direct your assets on your death. So those are trusts and last wills and testament, which we will talk about. Next slide. If no planning is done, if you don't plan, you don't have an advance directive or a power of attorney or a will, the law provides what happens with your assets and with your being. If you become incapacitated and unable to manage and govern your affairs and you have no plan, somebody has to bring a guardianship proceeding. You have to go to court. Somebody has to raise their hand and say, I want to and need to take care of this person and their assets. It will be very expensive because it's a legal proceeding. It's time consuming and exhausting for your friends and loved ones. There can be potential intra-family conflict and fighting. So if more than one person wants to serve and those people don't get along, there's going to be a fight, and the court will have to decide which of those people or both of them or someone else will serve as your guardian. The court can appoint an unrelated person to serve as your guardian, which is not necessarily a bad thing, but it may not be what you want. So it's really important to think about these things. And if you have a guardianship proceeding, the court will stay involved going forward. So if you don't have a power of attorney, and somebody has to be appointed to govern your affairs, that person has to do a regular accounting to the court to say, here's what the assets are, here's what I spent, here's why I spent it. And they have to go to the court. They have to prove to the court that it was all acceptable, and the court has to sign off on it. It's cumbersome, it's time consuming. It's not necessarily a bad thing because there are people who haven't planned for one reason or another, or don't have anybody to designate as their attorney in fact, or their caretaker. So the court is there to protect the incapacitated person or the alleged incapacitated person. But in order to do that, the court obviously doesn't know any of the players involved. So there's a lot of scrutiny that goes on, and it is a difficult process. So I do urge you all to think about that and really make sure that you get a plan in place. Next slide. So the law provides, as I just said, what happens if you don't make a plan and you're living. The law also provides what happens if you don't make a plan and you pass. So on your death, what happens to your assets? If you plan and you make a will or other testamentary disposition, you can give your assets to whomever you want. You can give them to your friends, to people who are not related to you, to people who are related to you. You could leave some people out. You could name your favorite charities again. You could do whatever you want to do with your assets, provided it's not something crazy and illegal. But the law provides if you don't have a plan, you don't have a will, you don't have any kind of plan, your assets will pass in general. First to your spouse, if you have a spouse. If you don't have a spouse, then to your descendants. Equally to your children. If a child predeceases you, then his or her share will pass to his or her children. If you have no descendants surviving, it will pass to your parents if they're living, and if not, then to your siblings, their children, then aunts and uncles. So it just keeps going out and out and out. So again, you see how important it is to make a plan, because if there are people that you don't want to receive your assets, a lot of people have family members that are not around, they don't talk anymore, they haven't seen each other in a long time, and maybe they have friends who are there caring for them and they want their assets to pass to the people who are there with them. You can do that. I say the law allows this general disposition, as I have spelled out here on this slide, because if you are in a second marriage and there are children from other relationships that are not the child of your spouse, the law provides something totally different. Everything does not automatically pass to a second spouse who is not the parent of the decedent's children. In that case, there's a whole formula. It's a little crazy and kooky. So if you're in that situation, you really need to think about what it is that you want to happen with your assets. You can go to the next slide. Thanks. So there are different mechanisms. I talked about them a little bit before, and this topic is very circular. Everything is related to everything else. It's not linear. So forgive me if I'm repeating myself, but everything just relates back to everything else. So planning for asset management during life. During your life, you could establish a power of attorney, which I said in your power of attorney, you name somebody to have control over your property and finances. You can establish a revocable living trust for asset management during your lifetime. And let me just take a step back for a minute. When I say asset management, I don't mean investment of the assets. That's a different topic and a different focus for a different discussion. But I'm just talking about literally managing your assets, knowing where they are, paying your bills, taking care of those types of things, controlling the assets more than what happens with the investments. It's a related topic, but it's a little bit different. So you can establish a power of attorney, a revocable living trust. You can also establish irrevocable inter vivos trusts. Those are trusts that you create during your lifetime. They are generally tax sensitive. They allow for tax planning. They allow for lots of other planning. That in itself is a very big topic that, again, we're not going to really get into too much today. We can have another conversation about irrevocable inter vivos trusts. It's a big part of estate planning and a very important part of estate planning for some people and for different reasons. But it is a huge topic that we're not going to get into too much today. But so those are generally the 3 vehicles to help you manage your assets during your lifetime. So with powers of attorney, a power of attorney, there are different types of powers of attorney. And again, with planning, you can kind of do almost whatever you want to do. A power of attorney can be limited or broad. So you can decide what assets somebody can control. A very simple example of a limited power of attorney is if you want to sell your house and you don't want to go to the closing, or you can't go to the closing, you could give somebody, your attorney or somebody else, the authority to sign all of the documents on your behalf. So that would be an example of a limited power of attorney. There's also a broad power of attorney and everything in between. So a broad power of attorney, you would give somebody the ability to transact all of your financial and legal affairs. You might omit some, you might allow others, but generally when I prepare a power of attorney for somebody, it's generally a broad power of attorney, and it has a lot of detail in it, but in effect, what it says is this person can do anything that I can do. So filing tax returns, signing contracts, bringing a lawsuit against somebody, defending a lawsuit if I am being sued, managing all of my banking issues and changing beneficiary designations, anything that I can do from a legal standpoint or financial standpoint, this person can do in my stead. One thing that you cannot, a power that you can't give away is the power to prepare a will. So you can't say in your power of attorney, this person can prepare a will for me. You can't give that ability away. So again, very important to plan and make sure you have a will in place or testamentary documents. Power of attorney can be immediate or springing. An immediate power of attorney is, I signed the power of attorney today. I name my friend Jenny as my attorney in fact. As soon as I sign that document, Jenny can go out and take care of all of my banking for me. She can move assets around. She can take care of investments if she wants to. She can sign contracts for me, sell my house, anything that I can do as soon as I sign that document. A springing power of attorney is a power of attorney that comes into effect at some later date that I designate in my document. Generally, a springing power of attorney says, I designate my friend Jenny to serve as my attorney in fact when I am determined to be incapacitated and unable to manage my own affairs. And that would have to be certified by 2 doctors. A springing power of attorney is very helpful in a lot of situations, but it is cumbersome to deal with because Jenny has to know that I'm becoming incapacitated and I need help. Jenny has to reach out to my doctors and say, I am appointed under this attorney in fact, will you make the certification? And Jenny probably has to talk to a lawyer who's going to draw up the certifications for the doctors to sign. Then Jenny has to take all of that information, the certifications, the power of attorney, ID, all this other stuff to the financial institution or wherever it is that she needs to go transact my affairs. So it's definitely more cumbersome, but it is important in certain situations. I'll give you an example. I had a client, a young mother. She was divorced and she had a minor child and her child's father was absent from the picture. And she was here in the US and she was a US citizen. She was here in the US, but her whole family was in Poland. And she had nobody here that she really trusted enough to name as her attorney in fact to give an immediate power of attorney. So we decided that we would give power of attorney to a very close friend of hers, and we would make it springing so that we were confident that while she was okay and she was able to manage her affairs, she would take care of everything. And this other person didn't have access to her, her financial and legal affairs, but only if there was an emergency, we would have to jump through the hoops to get him to be able to act. So that was, one of the few times that I've put a springing power of attorney into place, but there are other reasons for doing it. And it is effective and a good way to manage your affairs. I will say that an attorney in fact has a fiduciary duty under the law. They are required to act in the best interest of the principal. So if I prepare a power of attorney, my attorney in fact owes me a duty of care. They cannot steal my money. They cannot waste my money. They have to make sure they manage those assets in my best interest. So there is protection from the law, but still in certain events, you may want to have a springing power of attorney. I talked about this a little bit before. I'm sorry, this slide may be a little bit confusing. It's a little bit confusing to me when I looked over it, but I think, excuse me, the point here is if you designate an attorney in fact or agent, sometimes called an agent, You don't then need to designate a guardian of your property. That attorney in fact is your, it's either an attorney in fact or it's a guardian named by the court. You can, in your power of attorney, designate a guardian of the person, so somebody to care for you in more of a caretaker type role, if it becomes necessary to have somebody do that for you. But generally, when you have a power of attorney, you have an attorney in fact or an agent. Those terms are used interchangeably. And if you haven't planned and designated somebody, the person who has to go to court and ask the court to appoint them is known as a guardian. There's a guardian. There can be two different people, guardian of the property and guardian of the person. So the court may designate somebody as your sort of caretaker. That would be a guardian of the person, somebody who is there to take care of you and make sure you are personally taken care of. And then there may be a separate person who is guardian of your property, who manages all of your financial affairs and assets for you. Next slide. So part of lifetime planning, we talked about, I mentioned revocable living trusts. You probably have heard a lot about revocable living trusts. A lot of, I know Susie Orman talks about them all the time. And you'll probably hear lots of different things about revocable living trusts, whether they're necessary or not necessary. It used to be that in New Jersey, we didn't need them as much as we maybe do now, but I'll tell you what a revocable living trust is, as opposed to an irrevocable trust. They're basically just what they say. So if you establish a revocable living trust, it is a contract. It's a contract between the grantor or settlor. Those terms are also interchangeable. Contract between the grantor, is the person who puts the money into the trust, and the trustee. The trustee is the person who takes care of the assets for the benefit of the beneficiaries. So there's sort of three people involved. The grantor is the one who makes the gift into the trust. The trustee is the person who takes care of and manages those assets for the benefit of the third party, who are the beneficiaries. The beneficiaries are the ones who receive benefit from the assets of the trust. The contract that creates the trust, a trust agreement, can again pretty much say anything you want it to say. A revocable trust is just that. It is revocable during your lifetime. You can revoke the contract, you can amend the contract, you can change anything about it. You can hire trustees, fire trustees, do whatever you want to do with that contract that creates the trust. It is revocable. With that, there's not a lot of, or there's really no tax protection or tax planning for those assets. There's no creditor protection for those assets. But what the revocable living trust does is, if you put assets into the trust, then your trustee manages those assets for you, as opposed to your attorney in fact. And why is that helpful? It's helpful for a number of reasons. So let me just, again, give you an example. I establish a revocable trust. I am the grantor. I am also the trustee during my lifetime, and it's for my benefit during my lifetime. So I am all three of those. I'm the grantor, the trustee, and the beneficiary during my lifetime. I set up the trust. I go to the financial institution and I say, okay, I want to change title on my personal accounts to now be titled in the name of the trust. So now I have this bucket called the Christine Saletti Trust. revocable trust, and I put all my assets in there, and now they're in there, and I can manage them during my lifetime as if they were my own, right? I could write checks, I could buy things, I could make gifts, I could make charitable donations, I could purchase a home, I could do whatever I want to do with those assets. But if something happens to me and I'm incapacitated, now my successor trustee, who I've named in the document, goes to the financial institution and says, hey, you have a copy of Christine's trust agreement. I am the successor trustee. She can't serve anymore. I now have to manage those assets. And it's a relatively simple process. I mean, I'm making it very simple in this example, but the trustee steps into my shoes now, and they can manage those assets for me. Power of attorney does this a very similar thing, but with all of the new banking regulations and so many banks and all of the financial institutions being headquartered in different states and whatnot, we're finding that powers of attorney are sometimes not honored by financial institutions for any number of reasons. And one of the main reasons is it's too old. And what does too old mean? Your guess is as good as mine. We've had financial institutions say, we're not going to accept this power of attorney because it's a year old, it's 2 years old, it's 6 months old. How do we know it hasn't been revoked? So with a power of attorney, sometimes you're dependent on the financial institutions and their regulators and their legal departments and what their laws and regulations are. And if they say, I'm not accepting this, they're not accepting that. And you can fight it. And then you'd have to call me, and I can write letters to them, and we can do affidavits and other things to try and fix that. But it's another difficult process. Whereas with the revocable trust, it's generally a little bit cleaner because you've planned, you created this trust, you went to the financial institution from the beginning and you said, here's my document, I'm the trustee, but I want X and Y and Z to be the successor trustee when something happens to me. So they are already aware of that. They treat them a little bit differently, and it's just easier for your people to manage your assets. So revocable trust has become very important in many states. We do them for many clients, and we highly recommend them because they are a good vehicle to sort of, like I said, to pass the torch for asset management during your lifetime. The thing about the living trust is that, and again, forgive me, it's called different things: a revocable trust, a living trust, a revocable living trust. Those are all terms that talk about the same instrument. So forgive me if I use them interchangeably, and you'll hear them and read things about them, calling them different things. But the trustee only has control over the assets that you have put into the living trust. So anything that you've titled in the name of the living trust. So you still need a power of attorney because your attorney, in fact, like I said, can handle all of your other legal affairs, sign contracts for you, etc., take care of any assets that are not in the revocable trust. But if you get the bulk or a good portion of your assets into your revocable trust, that could be very beneficial for you. The revocable living trust, the contract that creates that trust, also can set forth, and generally does set forth, your wishes on the disposition of those assets in the trust on your death. So it can be a testamentary instrument as well. And you can set up trusts for people. You can distribute things outright so that the trust is no longer in existence on your death. But again, you can pretty much do whatever you want to do. The revocable living trust, again, only deals with the assets that are in the revocable trust that you've transferred to that trust during your lifetime or on your death. So you can also have a will that says something like, on my death, give all of my assets to my revocable living trust. Now, everything is in the trust, and the trust says, on my death, pay my assets to X, Y, and Z. That's what the trustee does. And you're good to go. A revocable trust is more private than a will. I'll talk about that a little bit too later when I talk about wills. But it is and a revocable trust is it avoids probate. Again, I'll talk about probate a little bit later, but probate is, many of you know, probate is the process that you have to go through when someone dies so that somebody can step into the decedent's shoes and wind up their affairs for them. The probate process in New Jersey is generally very easy, and compared to other states, it's very easy and very inexpensive. But with COVID, as everything has changed, and things have gotten a little bit more difficult in processing probate applications and taking care of probate assets. So the revocable trust is a very good vehicle to help with avoiding probate. Again, some states we absolutely want to avoid probate. New Jersey, depends on your situation. New Jersey probate is pretty easy in general, but still a good planning tool, the revocable living trust. The irrevocable trust, like I said, we're not really going to talk about it today, but an irrevocable trust is something different than a revocable trust. It can't be revoked. It generally can't be changed. Whoever you designate as your beneficiaries are the beneficiaries. You can't decide that you're not talking to those people anymore. You want to take them out. But it does provide tax planning and creditor protection. So they're a very important vehicle to utilize in certain situations. And again, you probably hear and read a lot about all different kinds of irrevocable trusts, life insurance trusts, ILITs, CUPRITs, SLATs. If you hear any of those acronyms, those are all irrevocable trusts, and we will save that conversation for another day. Next slide, yeah. So planning for your family. Oh, this is my favorite little little slide. My little friend there, planning for your family and friends after you're gone. How do assets pass on your death? Because everybody thinks, oh, I need to have a will, which is very important, and everybody should have a will. But the will is not the only way that assets pass on your death. And in fact, it's sort of a last resort. Last resort in passing your assets. So if you can remember my little friend here, this cow, and if you go to the next slide, you'll see why I have the cow there. It's an acronym. You can remember that on your death, your assets pass generally in one of three ways, either by contract, by operation of law, or by will. And again, will is generally the last resort. You can flip to the next slide. So the C and the O of my acronym COW, by contract and operation of law, these are, again, non-probate assets. They don't generally pass through the probate process. Now, probate and tax issues are different, so don't confuse them. Something may be a probate or a non-probate asset and still possibly taxable, but the assets that pass by contract or by operation of law are not governed by your will. They don't come into the hands of the executor or administrator, and they are considered non-probate assets. Next slide. So assets that pass by contract are assets that pass by beneficiary designation, or pursuant to a prenuptial agreement or divorce settlement agreement, for example, a revocable living trust agreement, or an irrevocable trust agreement. A trust agreement is a non-probate document and asset. Life insurance policies, retirement accounts, those things with named beneficiaries, that is a contract. If you have a POD or TOD designation on an account with a financial institution, so pay on death or transfer on death, that is a contract that you have at the financial institution that says where your assets go on your death. There are many different ways to pass your assets on your death, but again, you want to plan, you want to know what your assets are and where they're going and how you can get them there. So one way is by a contract. Most of us have either retirement accounts or life insurance policies. It's very important that you periodically check who your beneficiaries are, your named beneficiaries, because you want to make sure those assets get into the right hands. So if you come to me and you say to me, Christine, I want my life insurance policy to pass to my son, James, but you have the beneficiary designated as your son, Johnny, James is not going to get anything no matter what I say in your will. Johnny's going to get it all because he is the named beneficiary on your policy. So that's a contract that trumps your will. It's very important for you to know who your beneficiaries are and make sure they're designated accordingly. It's also relatively easy to change those designations. So, if you need to, you can just update them as need be. The next slide talks about operation of law. So assets pass, like I said, by contract or by operation of law. By operation of law means there is some law out there on the books that trumps your will. So if you and I hold assets as joint tenants with rights of survivorship, and I die, those assets pass to you, to the joint account holder. They don't pass pursuant to my will. They only pass to the joint account holder. Now that's if the account is titled as joint tenants with rights of survivorship. So sometimes you see JTWROS. That's what that means. That means there's a right of survivorship. When one person dies, the remaining joint account holder gets those assets, no matter what my will says. There is another joint account designation, and that's called tenants in common. Sometimes you'll see it as TIC. That is that does not have rights of survivorship. So tenants in common, if you own something as tenants in common with another person or persons, and you die, your share of that asset does pass pursuant to your will. It's only the the joint tenant titling, JTWROS, that passes outside of probate to your to the surviving account holders or asset holders. There is another titling with real estate and whatnot called tenants by the entireties, and that's if husband and wife own property together. So if your deed says, to Mr. Jones and Mrs. Jones as husband and wife, that is similar to a JTWROS designation, and the property will pass automatically to the surviving spouse on the death of the first spouse. It's a little bit different than joint with rights of survivorship, but in that respect, on somebody's death, it's similar. So that's another example of assets that pass by operation of law rather than, instead of under your will. Joint accounts and, real estate generally is where you would see those designations. And then finally, on the next slide, assets passed by your will. So anything that does not pass under pursuant to a contract or by operation of law will pass under your will. And those are considered probate assets. They are, if you don't have a will, they will pass pursuant to the laws of intestacy. So you may have a retirement account with a named beneficiary that will pass to that person. You may own real estate with, another person as joint tenants with rights of survivorship, that will pass to the named person. And you don't have a will, so anything else in your name will pass pursuant to the laws of intestacy. And that's what I talked about earlier. The law talks about where your assets will go. So first to a spouse, then to your descendants, then to your parents, and then your siblings, et cetera, et cetera. But if you have a will, you can designate where the rest of your assets go. And again, planning is so important, and taking all of these items into consideration is imperative, because if you come to me or you come to your attorney or your advisor and you say, this is what I want to happen on my death, that's great. I can create a will or a document that says this is where the assets are going. But if I don't know what other assets you have out there and how everything is passing, I can't really advise you properly. So it's really important that when you talk to your advisor, your attorney, when you do your estate plan, that you provide all of the information that you have about all of your assets, how titling is held, how, what beneficiaries do you have designated where, what are your assets, where are they, how are they owned, because you have to look at the whole picture so that I can then say to you, okay, here, you tell me what you want to do with it, and I will tell you how to get there. So all of these things have to be taken into consideration at the same time as you're doing your planning. Next slide. So I talked about this a little bit before about a pour over will. Your last will and testament can be a relatively simple document, or it can be very detailed, like anything else that we've been talking about today. Whatever your desires are, we can make it happen. You can have a pour over will to a revocable trust. The pour over will is a simple will. I kind of mentioned it before. It basically says, I name somebody to be my executor to manage my affairs and wind up my affairs. And then all of the rest of my assets should pass into my revocable living trust. And the revocable living trust says, this is where my assets go on my death. Or you can have a more comprehensive and complex will that says, I name my executor, and this is where I want my assets to go on my death. So your wishes can be all laid out in your will, or in a pour over will to a revocable living trust. Next slide. The purpose of a will is to, again, hopefully clearly set forth your wishes and intentions after you're gone, so that your loved ones and successors know what your wishes were and know what you wanted. Hopefully it is clear enough and has been executed properly so that people are not fighting afterwards. It's very important to make sure that you have a trusted advisor and attorney who can help you with this, especially if you have people that you think may be fighting over your assets when you're gone. And you want to make everything clear, because your family is already, I may have said this already as well, and I apologize if I did, but your family is already grieving your death. They don't it just makes it so much nicer for them and easier for them if they know what you want. I know a lot of people don't really want to think about this, but the one thing we all know is all of us are someday not going to be here. The one thing that that is certain, right, is that we're all going to move on to the next life or pass from this earth. They used to say death and taxes, but I'm not even so sure about taxes anymore, although we're pretty sure we'll always have them. But that's a whole convoluted issue. But the one thing we can all be sure about is that someday we won't be here. So it is very helpful to your friends, family, loved ones to know what your wishes are. So you have a will and your whole estate plan. Your will designates your fiduciaries, so your executor, trustee if you need one, and guardians for minors or incapacitated children and dependents if you need that. The executor role is relatively limited. If any of you have served as an executor in the past, you will agree with me and understand when I say it is not fun to be an executor. It is hard work and it's not an honor. It is something that somebody will do for you because they love you. The executor has a fiduciary obligation to the beneficiaries of the estate, but the executor's role is limited to stepping into the decedent's shoes, at the time of their death, and winding up all of the affairs of the decedent. The role can last anywhere from 6 to 18 to 24 months or more. But essentially, what the executor's role is to gather all of the decedent's assets, to determine what the decedent's last debts are, valid debts, to pay those debts, to file any final tax returns and any other required tax returns, to pay those taxes, any taxes that are due, and to take anything that's left and pay it to the beneficiaries pursuant to your testamentary plan. The trustee's role lasts longer. If you set up a trust of any sort, the trustee is the person who manages those assets and distributes the assets of the trust to the beneficiaries pursuant to the terms of the trust. So the trustee's role can last for years and years and years. A trustee can be removed, a trustee can resign. Executors and trustees and guardians all are allowed to get paid for their services. And there are statutory dictates and mandates on what those fiduciaries are allowed to get paid. Guardian for a minor child is extremely important for you to designate somebody. If you don't, again, you could have family fighting over who's going to serve as the guardian, or potentially you're going to have nobody stand up to serve as the guardian. So what's going to happen to your children when you're gone? The guardian is the person who takes care of the minor or incapacitated person in what I call a parental type role. They are the guardian of the person. They take care of them. They are their caretaker. They make sure they're healthy and they take care of their day-to-day existence and events and things. They don't take care of the person's property unless they are designated as a trustee or a guardian of the person's property. So you can name the same person in all of those roles, or you can name different people in those roles. Some people say, my son is a great, he's a financial wizard and he's really good, and I think he would be an excellent trustee, but he, lives somewhere far away and he's got a job that he travels a lot, so I don't think he would be the right person to be the guardian for my child. But I have a friend over here who lives nearby and they have children the same age, and they said that they would be able to take care of my child. So I want that person to be the guardian. And then they just need to coordinate. So the trustee and the guardian may be the same person, may not be the same person. The will also will set forth your intentions regarding taxes, bonds, and commissions. So like I said, an executor, trustee, and guardian, they're all entitled to commissions under the law. You can specify in your will that you don't want that person to get paid. I don't know if you could do that with the trustee actually, but you can certainly do that with your executor. But I caution you against that because it is a really difficult role. Sometimes I advise my clients, if they're serving as executor, not to take their commission for various reasons. It is considered income to them and they would have to pay income tax on it. Maybe they're also a beneficiary, so they can get it that way without paying taxes on it. But I think you should always provide in your will that your fiduciaries can take their statutory commissions. If you designate a financial institution to serve as a trustee, they have a rate, a schedule of commissions that they charge, which in my opinion is well worth it. It is oftentimes helpful. It makes a lot of sense to have a corporate fiduciary, a corporate trustee serving, not just, a friend or an uncle or an aunt. Because they know what they're doing. They have deep pockets if they make a mistake and they get sued, so they can replace any funds that they lose. And generally everybody now is busy. So why not have a professional managing those assets, especially if you have young children, and the assets are going to remain in trust for them for a long time. The corporate trustee can be very, very beneficial. Just something to think about, but they have their schedule of trustee fees and commissions. Your fiduciaries are required by law to post a bond, but you can, in your will, waive that bond. We always do in our wills. I should probably never say always, but we almost always waive that bond requirement in our wills. It's very helpful. Somebody who is stepping up to the plate to wind up your affairs for you is probably somebody that you trust, hopefully somebody that you trust, and they don't need to be putting money out of their own funds to post a bond if they don't have to. And you could put that in your will that they don't need to. Also, will set forth your intentions regarding your taxes, and then it sets forth your testamentary disposition for your probate assets again, including your personal property. So if there's anything that you have that you want, you have a special ring that you want to go to a certain child, you have another piece of artwork that your friend always admires and you want them to get that, you can specify all of these things when you create your will. So a will, I could talk for hours and hours and hours about wills and what they do and what you can do and what you should do and what makes sense and how they work. But in general, those are all of the important items for you to be thinking about when you are doing your own estate planning. The next topic, which is related to all of this, but a little bit separate, is planned giving. So we talked about, how you manage your assets during your life, and then on your death, what are the different vehicles that set forth your intentions and take care of how things are wound up. And part of that during your life and on your death is planned giving. And planned giving is, you can turn to the next slide. Planned giving is just another way to make a gift that requires some kind of plan and thought. So I can give $10 to Crossroads for Hope today, And I can make a planned gift. So planned gift is another way to make a generous gift to your favorite charitable organization, and importantly, leave a lasting legacy with assets that you no longer need. We all are living. Living is expensive. We have our assets. We do our thing. We live our life. We go on vacations. We pay our mortgage, all of that. I have a little bit extra. I can give it to Crossroads for Hope today. But when I'm gone, I have my home that I've been paying for, and I have my assets that have been helping me, so I can travel and whatnot. And I don't need them anymore. So we can come up with creative ways to get those assets to our favorite charity that has helped us along the way, so that they can keep helping people in the future after us, in the same way that we got help from that charity or those charities. The next slide talks about why you can consider planned giving, benefit your favorite charity, to pay it forward, right? You're being benefited now. You want Crossroads for Hope to be able to do these things for people long, long, long into the future. So you pay it forward when you don't need the services anymore and you don't need your assets anymore. They can utilize them. You can leave a legacy. You can be named. You can make a gift with a naming opportunity. This room could be named after you. Something, it could be creative as creative as everybody can come up with. And that's why we make a plan. Maybe you want to be recognized, maybe you don't. I will say one thing that's very important to think about recognition. A lot of people say, no, I want to make an anonymous gift. I don't want to be recognized. I'm just doing this from my heart. But when you put your name on something, it inspires people. It inspires other people to give. And it's really, truly helpful for the rest of the people who are with you or come after you. So think about some naming opportunities. It's helpful in a way that you may not even realize. Planned giving is beneficial, can be very beneficial to you and your other beneficiaries because it can provide tax savings. So if you have $100 in your bank account, and you have $100 in your IRA, and you want to give $100 to your child, and you want to give $100 to Crossroads for Hope, I would generally say to you, designate Crossroads for Hope as the charitable beneficiary, the beneficiary on your IRA, because they will receive that full $100 without having to pay tax on it. Your child will receive the other $100, and everybody gets their $100, and there's no tax paid. If you did it the other way, your child would receive the IRA. They would have to pay income tax on it, and if it's not a child and it's a friend, they may have to pay an inheritance tax on that asset as well. But if they receive the IRA, they will only receive a portion of that $100. The charity will still get their 100 if you give it to them from the cash, but now your child is not really made whole in the way you want them to be. So again, planned giving requires a full conversation about all of your assets and all of your desires and ways to figure out what makes the most sense to everybody, to you, your estate, and your beneficiaries. And then, of course, a planned gift can be maybe larger and more beneficial than you ever could imagine, right? Because you day to day, we think, oh, I don't really have that much money. I'm paying all these expenses, but now you're gone and everything's there. You can really, really make a difference. The next slide talks about ways to make a planned gift. And again, I won't get too much into detail about any of these, but and this is just a sample. There are other ways, but you can make a bequest in your will, which would require you to go to an attorney. It's one of the simplest ways, but you do need to go to an attorney generally to make a will. Your retirement assets, like I just said, you can just designate a charity or charities as the beneficiary of your retirement assets. And it could be all or a portion of a percentage or a fixed dollar amount from your retirement accounts. You can donate appreciated securities during your lifetime. So if you bought stock for $10 and today it's worth $100 and you sell that stock, you're going to pay an income tax on the $90 of gain. If you take that $100 of stock and give it in kind to Crossroads for Hope, they take the whole $100. They don't pay any income tax on it. So you've avoided the income tax there, and you've given them a larger gift than maybe you otherwise would have. So appreciated securities are a very good way to make a planned gift during your life. Life insurance, of course, you can designate them, your charity as the beneficiary of all or a portion of your life insurance proceeds. You can give real estate during your life or on your death. You can give personal property. You have to check with the charity. Some charities won't accept personal property for various reasons, but you can give artwork or collections to Crossroads for Hope or your charities. And then, of course, charitable trusts, I talked about a little bit before. Irrevocable trusts, you can establish charitable trusts, but that's again another very large and detailed topic that we won't get into today. So those are some of the ways that you can make a planned gift. And then the final slide is just a list of important information that you should gather now while it's on your mind. And certainly if you are doing an estate plan, and leave it for your loved ones. So you should have, I don't know if you remember when they used to say, you should designate somebody in your phone as your ICE contact, ICE, in case of emergency. This is your ICE box. In case of an emergency, look in this place. You don't have to give all of this information to your family and loved ones today, but you should tell them where to look, and you should gather all of this information for them so that they have everything there at their fingertips and they don't have to go searching and searching and searching. Once upon a time, we used to tell clients, check the mailbox for the next couple of months, see what comes in, and you'll know what all of the accounts are and what all of the debts are. Now, everything comes through email, it's on this app, that app. So if you can, while you're thinking of it, gather all of this information and put it somewhere so that your loved ones know where to look and know where to find these items. So things like the names of your financial and legal advisors, names, contact information, everything. The names of all of your financial institutions. Probably the best way to do that is to collect all of your statements, your bank statements. If you get them by email, print them out every now and then, put them in your box so your loved ones know what's there, what your assets are. Make a list if you can make a list or need to make a list. Keep an Excel spreadsheet, whatever you think makes sense to you. But remember, people need to be able to access this later. So if you put your ICE box into your safe and nobody has a combination to the safe, is that helpful? Somebody has to drill it, whatever they have to do to get to it. Safe deposit boxes are amazing as well. But remember, you need to name somebody to have access. You need to tell the bank that a particular person or persons should have access to your safe deposit box if something happens to you. Otherwise, they need to drill and provide other information to them. It's just a little bit more cumbersome. When I say hidden assets, maybe you have some assets hidden under the mattress, but really what I mean there is anything that somebody wouldn't think of or wouldn't know about unless you specifically said to them, I have this asset in this place, and on my death, look for it and collect it. Um, if you, like I said before, if you have personal property and you want to give specific items to specific people, make your list. You need to reference it in your will if you have one, but at least if you have a list in your box, people know, oh, she wanted me to have this, she wanted me to have that, she wanted you to have that thing over there. And then of course your passwords and login information, also so important. So gather your information together. This is something that you can do on your own, and really you have to do on your own. There's probably nobody that can do it for you. Gather it now, keep it updated as you can, however often you need to, monthly, quarterly, yearly, something. It is not a fun process, but it is helpful. And once you do it the first time, it's much easier to keep up with it. And your family and loved ones will be so appreciative.